Hello, everybody. Hello, C-Rex. I'm sorry to keep you up. Hello, Nina Laura. Hello, Spider-Man. Oh, that's so cool. Well, welcome home, grandson. Hello, Charlie. Hello, Sherry P, honey. Happy Friday to you. I still didn't make it to Peru. But I have someone who says they'll help me on Sunday. So I'm planning on that. Because it's a lot. And I can, but I can't really do it myself. I like to think I'm Superwoman still, but I'm not. Hi, Ava. Ava broke her collar. The one that Palmy sent her. Yeah, she snapped it. So, I got her a new one from Walmart, just something to have, because it wasn't really safe just hooping the leash over her neck and hoping for the best. Especially, I mean, she broke that thing in, what, a week and a half? 2 weeks? Yeah. When the neighbor's dog comes out, there's a chain link fence, and they like chase each other back and forth. And I used to think that it was aggression, but her tail's going 90 miles an hour the whole time, so I can't really lay it on that. So I don't know. I just know she snapped it. She's a tough cookie. She is a tough cookie. Yeah, and who knew I would find two soft sits or soft sit adjacent or whatever. The first one was a bona fide, genuine soft sit. This one, I'm sure, I mean, he might be soft sit adjacent. He's got tendencies. He brings up Black's Law Dictionary, and you'll see. He's just, I swear I have seen this man before. If I haven't run him before, which I believe I might have, I've at least seen him before. So, yeah, you're in for a treat. I got a lot of stuff tonight. Mortimer Duke just kept sending me stuff. And, yeah, I couldn't even fit it all in the stream. I couldn't. I've got, at least, I think by the time I cut all the dead spaces out, I have like 60 hours of Licking County, Ohio. So I went through a lot of that. And then we've got Judge Stevens. We've got two judges from Licking County, Ohio. We have the Black's Law Dictionary dude. We've got a bunch of stuff to go through tonight. Yeah. It's like 2 hours. So I'm gonna need your help. Because I'm a little sleepy. Just a little bit. I did take a nap. But I'm a little sleepy. So I'm gonna need your guys' help. You gotta keep the jokes coming. Keep me laughing. Keep the comments going. So I don't doze off. Hello, Buzzy Pug. I had fun editing this. Yeah. I really like him too. And he had a day. Yeah, he did. So I only included one case from the day, but it's so worth it. So worth it. The thermos is freshly filled, and it's still too hot to drink. I'm going to be trying, though. You're darn right. I'm going to be trying. All of the PAWFURM, they all got their flea treatments today. So that's taken care of for the month. Yeah. It's a good day. Good day. Yesterday I spent cleaning my house. Yeah. So I'm exhausted. A movement? What movement are you talking about? Oh, the soft sits? Yeah, no, none of them have learned their lesson. It's a mental disorder. I am 100%, I stand by that. There is a narcissistic mental disorder that has to be associated with how these people are at least susceptible to the ideas about the whole sovereign citizen BS, because they all have the same traits and tendencies, and like the one we saw earlier today where he's like, I don't like being told what to do. Okay, buddy, good for you. You're in a court, and that's kind of the judge's job. And yeah, soft sits, I swear, it's a mental disorder. It's another one of those derangement syndromes. All right, guys, let's have some fun, and don't forget, you gotta keep talking. By the way, where's Mortimer Duke? Speaking of which, he's probably napping in his chair because he asked me if I was going live, and I was busy editing. I made the thumbnail early and I forgot to post it. The screen was still up waiting for me to put the title and caption in, but I was editing. By golly, I was working hard because I needed to get it done so I could be live at 11:45. Yeah. And I got distracted. So sorry for the little later than normal notice. Oh boy. Oh boy. I'll have to look that up. Yeah. I'm sure somewhere someone's got a playlist of him. Probably on Van Balen or something like that. It starts with Van. He's a big soft sit follower guy and exposing soft sits and stuff. He does a really great job with his channel, but I don't really watch it so often because this. If I'm going to be watching court stuff, it's going to be stuff that I get to stream. And I don't steal people's content. So yeah, right, for sure. And the whole logic of what gets me is the whole logic of needing to speak to the injured party. Who is the injured party? Okay, buddy, you think we want to wait until you injure us because you're driving and you have no license, registration, insurance, none of that stuff. You think we want to wait to be your injured party before it's handled? No. I'm sorry. Like, Most people don't even have enough insurance to cover the damages that are caused in a motor vehicle accident. As it is, with mine, the insurance payout just covered medical bills, barely. The one from the company of the lady that hit me. So we have to fall back on my insurance for the uninsured and underinsured motorist coverage, which unfortunately resets that 3-year clock. So it could be up to another 3 years before my accident case gets settled. All because they didn't have sufficient coverage to cover, I don't know, a spine injury. Because they had to get across the highway quickly. Couldn't wait their turn. Cut off an SUV and boom. And then the SUV turned my way and boom, right into my door. Yeah. What are you doing? The treats are not even over there. They're on the floor. And you shouldn't even get them. You've been so naughty. She's already gotten lots. So don't let her fool you. She has gotten so many treats and so many kisses and so many snuggles, but she did get scolded because I found that she hasn't learned her lesson, and yeah, she's still finding places to go potty on the floor, and I'm not happy. I'm not happy about it. I made her own custom kennel with blanket, and it's got her own litter box in it, and the door is actually wide open, and there's like a path behind that dresser, so she could easily go on the bed all the way to the end of the wall and behind the dresser and completely circumvent all the other animals. Will she do it? No. Nope. It's just better to pee on the floor. Oh, I'm so mad at her. I love her. I love her more than anything. Don't I? Yeah. Okay, guys. Let's see here. Oh, that's what I named it.
All right, thank you, Madam Monitor. And once again, to the plaintiffs, Mr. Stephen Stanley, if you could just turn on your camera for the court.
Hold on, I have to get the officer. He's coming right now.
All right.
Because I don't see you either. You're still there, right?
Yep, I'm
You
still
just
here.
turn on the camera, he said. There's no video thing.
No video?
Yep, if you could
The
just turn
officer's
on.
right here. Hold on 1 second. He said for you to turn on the camera. I didn't want to touch nothing.
Control shift.
What's up? Trying to get, they asked for the camera to be put on. Because I don't see them and they don't see me.
When you click on it, nothing happening.
I'm just gonna sign out and then sign back in.
You want me to tell them or? We're gonna sign out and sign back in, so give us 1 second. That's what we-
There we go.
Okay.
That should work.
Do you have me now?
Yep, perfect. So we can
I
see.
don't see you though.
Yep, don't worry. The judge will be joining shortly.
Who do we have for a judge today?
That would be Judge Graff.
Thank you.
Good afternoon, everybody. The Town Superior Court is now open and in session. The Honorable Judge Graff now presiding. Good afternoon, Your Honor.
Good afternoon. Good afternoon, everybody. We're here on the matter of Stephen Stanley versus Harold Stanley. The docket number is 2450-18168. Can I have the parties identify themselves for the record, please, starting with Stephen Stanley?
Yes, for the petitioner, Mr. Stephen Keith Stanley.
And do we have,
I believe it would be Kevin.
is Kevin on?
I was told that Mr. Kevin Stanley would be joining us today, although I do not see him
He's
logged
been
on.
there since 1 o'clock.
Okay, hold on, Mr. Stanley. Let's just see.
So
That's
let me
okay.
reach the clerk's office to find out how this is going. I'll be right back, Your Honor.
Okay. I'm just going to mute myself until we get him on, okay?
Thank you.
You're welcome.
Hey, what's up? How are you, Your Honor?
Hi,
What's up?
Mr. Stanley. All right, so it looks like we have Mr. Kevin Stanley with us. Mr. Stanley, can you hear me okay?
Yes, ma'am, I can. Thank you very
Okay,
much
great.
for everything
Thank
that
you.
you're doing. Yep.
Thank you. Thank you for joining us. All right, we are here on entry number 142, which is the motion to waive a filing fee, which Mr. Stephen Stanley filed, which was denied by the court. And Mr. Stephen Stanley, you were looking for a waiver of a fee for a jury trial. So did you want to be heard on that, sir?
I do, Your Honor, yes.
All right, you may proceed.
All right, so under Connecticut General Statute 52-259 lower casement B, clearly says anybody that's incarcerated or collects unemployment is indigent under the eyes of the court. In the State of Connecticut State Registry and Manual, amendment, the Constitution of the United States, the 7th Amendment, and it states, and I will quote, in suits as common law, comma, where the value of the contrary shall exceed $20, comma, the right of a jury trial shall be preserved, comma, and no fact tried by a jury, comma, shall be otherwise re-examined in any court of the United States, comma, than according to the rules of the common law. So therefore, again, Kevin Stanley was a defendant at the de novo trial. The problem is that we had a trial in December with Judge Gordon. Well, my brother's attorney father died that day. So all my subpoenaed witnesses, the court's subpoenaed witness that came voluntarily, everybody, even Kevin, everybody was there that day. Well, because of the illness and his father's death, there was no objection to anybody to prolong it where it went till February. Well, February, now we have David Sheridan, Judge David Sheridan, and now he's failing to comply to the granted court order of a jury trial, which was already number entry on the other docket, number 127 and 129 of closed pleadings. There was no objection, nor was there any filing of an affidavit from my brother's attorney. So therefore, again, and under that docket number, he abandoned the petition because he didn't object to my jury trial that was already entered, 127, or actually the fee waiver was 127, and the jury trial was 129. And if you like, I could give you that docket number. Would you like that?
Yeah, yes, that would be great. Thank you.
Okay, so that entry number of that docket was TTD-CV 22-501-6509-S. And that was number 127 was the case, well, you'll see in the case for lookup. 127 was the trial, and 127 was the fee waiver, and 129 was the jury trial. And I believe, 127 was the jury trial, and then 129 was the claim for a jury trial, and the closed pleadings was entered, but it was never ruled upon. There was two of them, and that one prior. So therefore, again, this case originated for a jury trial, all the subpoenas, everybody that took place. Well, here we are today, because it never took place with Kevin being there, no jury, no nothing took place, and the defendant, my brother's attorney, failed to object to any of these filings. So therefore, again, under Connecticut Supreme Court rules, federal laws and Supreme Court cases apply to state court cases, and the statutes do not apply. So therefore, again, he abandoned the petition. By Kevin not being there at that trial originated. So therefore, again, we're back to my 52-259 lower casement B that clearly waives, and you've said on other things that the court don't waive certain things. I've had, all the way back from the trial courts, the courts have paid for my practice book. They've ordered a place in Enfield to provide the practice book. They've waived the fees for statute books, Judge, I forget the name, the last trial just in Rockville, they actually waived the fees for the statute book, gave me a brand new statute book, every kind of law book, and even Judge Newsom in 2018 waived all legal copies, postage, everything, and I can even give you that docket number if need be. So therefore, again, a fee waiver is used for many things in the court's procedures, and my things have been granted. Even one of the worst judges I've ever ran across, Judge Quack, he granted the practice book. So I mean, if I'm pronouncing that right, I believe that's his name. Not trying to be smart. And again, judges across the board have granted several things. So therefore, again, under the registry and under Article 7, I am entitled to a jury trial for anything over $20. Kevin Stanley was never there. It never took place of a jury trial. I withdrew that entry prior to that hearing, and on the record, and I can give you the transcript. You were going to say something?
No, go ahead.
Okay, so anyways, I withdrew that on the record, and on that hearing date, again, my brother's attorney failed to file a counter brief to pick up that docket number so he could reclaim it to reopen the file. So therefore, again, it was never a jury trial. Matt Grimes filed an objection already. I filed an objection. I don't know what entry you have. My motion is dated 6/6, and it's a motion opposing and object to the defendant's May 27, 2025 objection to the last parties of record of a jury trial. And clearly, I stated really clearly that the court granted his summary judgment. So therefore, again, if we go down to my legal arguments, I stated he's not a party of this record no more, nor does his motion have any stand, so it would be considered moot. So therefore, again, it is me versus Kevin Stanley where we can't come to an agreement. I've already explained to you before when our last hearing that we need we could pick jury date on the same day, and we can have this jury on same day. Attorney Danforth, he was coming to court voluntarily for Judge Gordon before, and I've reached out to him again through my people, and he's willing to come again. The court just has to pick up the phone and just request for him, and he said he would give his expert testimony. Kevin, on the other side of being defendant, had no objection to Attorney Danforth. I'm not even going to subpoena anybody. I even have the Secretary of the State of January 15th of this year has recertified that handwritten will to make it authenticated. Therefore, again, it is January 15th. It is bound, sealed, and riveted together that they authenticated that handwritten will. That is the valid will. I have a federal case law that I've submitted in exhibits before. Aretha Franklin, we're all aware of her, this artist.
Yes.
That question was for you, Your Honor. So anyways, they found a handwritten will in her couch cushions, and I've submitted the documents. I don't know if you have it or not, but a handwritten will was found 2 years after the fact, and they honored that handwritten will that they found in a couch cushion, under a couch cushion, in a jury trial in a federal court of law. I have the whole case that awarded that a handwritten will is valid. So therefore, again, Kevin Stanley had forfeited any rights to be in anything to do with his estate in 2008. He forfeited it all to me in 2008. So therefore, again, he could be a certified witness in the 2010 new handwritten will. And even my mother says that she vacates that old will, and this is the new will, what her last dying wishes wanted. So therefore, again, I'm asking for a jury trial. I'm not trying to be belligerent with the court. I figured we could knock this out in one day, and we're having one expert witness come in, Attorney Danforth, that was coming in voluntarily for the court. With your permission, again, all you'd have to do is pick up the phone, and he would appear again on courtesy for the court. So therefore, again, besides the jury trial and my statute that I listed, I'm entitled to it. Again, as well, the state's registry guarantees my right for a jury trial. You checked my fee waiver off in the area where you didn't list nothing, and we go back to other fee waivers. I can give you the entry number where you said they weren't ripe at the time and this and that. We're moving up now where we need this jury trial between me and Kevin because we can't come to an agreement. We could knock this out in a day, and I'm sure we could probably get a ruling ASAP. And again, so I'm asking the court to waive the fees for the jury trial, which I'm entitled to. As you know, I'm sentenced to 30 years and I have no money. So therefore, again, it is very crucial for myself to have this jury trial so we can get to the bottom of this, and it would be done, I'm assuming, within a day.
The issue, Mr. Stanley, is that General Statute Section 45A-98A,
Yep.
parenthesis B, states that if a party fails to file an affidavit of intent to claim a jury trial prior to the initial hearing in the probate court on the merits, or having filed such an affidavit,
And can I
fails to-
stop you for a moment?
yes,
Okay, at the probate court on 2 hearings, and I have exhibits ready to go to show you, on 2 hearings, they had me on the phone, they disconnected me twice. So therefore, again, they abandoned my right for a jury trial. I filed a habeas to be habeas in from the beginning. The Judge Gardner in probate court declined, and you cannot refer, just like I told Judge David Sheridan, you cannot refer to anything of the probate court because we had a de novo hearing which vacates that probate court. So anything that went wrong with that Judge David Sheridan kept referring to, or anybody else, is irrelevant and moot. In Connecticut General Statute, I got a whole book of endless case laws, federal and the Supreme Court cases, that when a de novo hearing is entered, all other existing trials are moot and they're basically irrelevant to the fact. And anybody that cites anything to that knows better, and that it can't be used against you in a court of law. So therefore,
Well-
again, with Connecticut General Statute, because of my indigency, therefore, again, we never had a jury trial. You'll see my entries. I've never abandoned the petition. If anything, the defendant abandoned it when he didn't object on the record, nor did he file any motions. There's nothing in the filings of all the filings of the of that docket number that I gave you where he was opposed to objection. So
As Mortimer Duke says about our favorite AI, J-Regier, Robot Regier, why use 10 words when 100 will do?
we must refer to the trial court of the de novo, where there was never no objection to my jury trial.
All right,
And on the
there's
record, I withdrew it that day, so that stopped everything. Whether the ruling that Judge David Sheridan filed or not, a person is entitled to a jury trial, and I got Connecticut Supreme Court cases that says that's an automatic reversal as soon as he denied me my rights for a jury trial. So therefore, again, the statute that you're citing, by going back to the practice book, it does not apply to this case at hand, Your Honor.
okay, but you understand which statute I'm referring to, just
I
so
am.
okay. I just want to make sure you understand the basis of why I denied the fee waiver was because there's no indication that in the probate court proceeding, you filed the proper paperwork or affidavit with showing that you had the intent to claim a jury trial of the probate court's decision. And under that statute, if you don't do that at the probate court level, you can't have a jury trial on a probate court appeal.
Okay, but again, when the hearing we had, the de novo hearing is a de novo hearing. It was not an appeal. It was a hearing. You keep referring to the probate court. The Connecticut General Statute of the Supreme Court of Connecticut confirms that a de novo hearing, it says I can read the law book even, and it says it stops all proceedings in the probate court, and anything from the probate court is irrelevant and moot. So yourself, by keep citing it, that's like me right now citing the statute book where I filed this case in Hartford. Matt Grimes, you gave him summary judgment. I tried to say you didn't have jurisdiction because it was transferred improperly to Rockville. You didn't abide by your own statute book that says it is the option of the petitioner, mine. So it was illegally transferred to your jurisdiction. I feel, now we're citing the statute, not a practice book. We're citing the statute. The law says it was my option where it would be filed. They have a hearing in Hartford where it should have been. You jumped over jurisdiction. I don't feel you had it. You gave him summary judgment, and I explained to you on the record that says when there's any evidence or any exhibits in dispute, and if I don't consent, summary judgment is off the chain and it's gone. And the law book says, again, you keep referring to the probate court. We cannot refer to the probate court, and anything you're citing from the practice book doesn't apply because we did not have an appeal. We had a de novo hearing, and I can read in the law dictionary, Black Law Dictionary, it says anything of a de novo hearing, it has irrelevant of anything at the probate court, and that has nothing to do, and it's moot. And if you like, I'd pull it out if you want me to read it on the record. I think you know what the Black Law Dictionary says about the probate court and de novo hearing, that everything from the probate court is irrelevant, Your Honor. So therefore, again, I'm not judging you, but I believe that you're totally wrong in that hearing that we had, where on me on the record, I withdrew it right then and there because you wouldn't accept my motion. So therefore, again, that's an automatic reversal. And I had my entries for a jury trial as well as there was no objection. So therefore, again, if anybody abandoned the petition, it was the defendant, because he didn't even file anything for a counter brief objection, nor did he file anything to reopen that docket number. So again, I do believe I'm entitled to a jury trial on my indigent status. I'm sorry.
That's okay. I didn't mean to cut you off. I understand your position. Is there anything that you wanted to add, Mr. Stephen Stanley, before we adjourn?
No, it's just that, Your Honor, that I feel that you're hindering my case and you're blocking me. I have till August 11th for the appellate court, and this would be evidence right here to support everything that would vacate that. And again, endlessly, the defendant, I'm going to give you a scenario. The defendant asked for 7 extensions in the appellate court. In 15 months, they granted everyone. I filed 1 extension for my counter brief asking for an extension for 120 days. They gave me 5 weeks and they said, this is your only extension ever. You talk about being biased. So again, my only resource is here today in this court, where we even have housekeeping matters of endless motions that are filed that even ask you about a bill of particular that nothing's been ruled on, all these things. Any housekeeping matters, the law book even says that we're supposed to, all issues come to a halt till we address the housekeeping matters, where we have these endless affidavits supporting exhibits and everything that should have been addressed long before this hearing, and you went ahead and granted summary judgment. Now you're telling me that you're denying me my civil right for my fee waiver. We're only here at an indigent status, Your Honor. So that fee waiver that you denied, you didn't check anything else saying denied for frivolous, anything that you checked the box where it was blank. So the only thing that is checked for that we're here today is Mr. Stephen Stanley indigent. In the eyes of Connecticut, I am. So therefore, again, we need to proceed forward to this jury trial.
All right. Mr. Kevin Stanley, is there anything that you wanted to add?
I just, how's he doing for an attorney, my brother? How's he doing is he doing all right? I think he's doing good.
All right.
Can I ask you a
Mr.
question if I can?
Sure. What did you want to ask him?
Do you have any objections to anything I said today about you wanting a jury trial?
No, me, no.
Okay. Do you want a jury trial for the first time because you were not heard at the probate court, nor were you heard at the de novo hearing?
Yes, of course. Of course I
Are
do.
you wishing a jury trial?
Yes.
Thank you. So because we both disagree, you're asking for a jury trial as well as I am, correct?
Yes.
Thank you, Your Honor, for bearing with
All
me.
right. Okay. All right. I understand both your positions and I understand your argument, Mr. Stephen Stanley. So I will take another look at it and issue a ruling. Is there anything else that you wanted to tell me today?
I would just like you to go back to that other document number I gave you and see the entries where there was, if anything, if there's any abandonment, I filed my jury trial that was marked off, by the way, for the court, marked off. It wasn't rejected, it was marked off. So therefore, again, I had closed pleadings entered. I even had the jury claimed. Everything was entered, Your Honor. So it's proper to meet the floor mat as you're stating in the probate court, but the de novo is the probate court and everything was all in order and there's no objection.
She'll do her
to the
job,
defendant.
man.
There was no objection to the defendant. So therefore, again, if anything, he abandoned it because, for one, he didn't object to me asking for a jury trial at the de novo. Everything that you say, I agree with you 100% that I need to request for these things ahead of time. They were all entered because the de novo hearing is taking the place of the probate court. Like we all agree, the probate court didn't happen. So everything, the entry numbers, Your Honor, 127, 129, if you look at all the entries, you'll see everything is properly filed and there's not one objection. So therefore, again, if anything, it's abandoned by the defendant because he didn't object to me asking for a jury trial, nor did he even file a recounter to reopen that docket number for anything about that case when I withdrew on the record. So I believe for everything I'm telling you, and if you do your due diligence, you will see that the de novo hearing, everything was entered exactly what you're saying that would take place of the probate court, Your Honor. So I'm asking you to expedite this so that we can get this resolved in the next couple weeks, so that I will be on board at the probate court where we can have the Secretary of the State statement that Kevin has the confirmed documents that it's re-authenticated at the Secretary of State, signed by the Secretary of State, that we all abide by, and he has it in his possession. If you need to see that, I told him, don't pull no rivets out or nothing. Leave it the way it is, because that is a authenticated document. So therefore, again, that Secretary of State speaks for itself about this new will is the valid will. So therefore, again, I'd like you to take everything in, under advisement, and if you need to, I'm sure Kevin Stanley can produce that for you to witness that brand new authenticated, that verified this new will is the law of the land.
Thank you,
Okay,
Your
but
Honor.
you're asking, there's something that you said that I may have misheard. You're asking for a jury trial in the Superior Court, not in the probate court, correct?
That is correct, because again,
Okay.
we're back to this is not an appeal. I'm asking for a jury trial in your court of law, where basically, I'm assuming that we could knock this out in one day. I don't see a problem with picking the juries. I've even had my last trial in the other court, and we knocked out a criminal jury trial, I think, start to finish within 7 days. So basically, I think we could pick the juries within a day. We could probably even have the trial the same day. So it's not a burden of the court. The point is that I've asked for this for quite some time, and I think that this needs to be expedited immediately, where we can just get this on the record, make this happen, and put this case to bed once and for all. You got to understand something. That house and land, my brother Kevin sitting right there, he took 150 grand cash out of his account, built a house and a garage on that property, and my brother and his attorney had him evicted from the property. So let's just say hypothetically the old will is still valid. Well, the property is between 5 siblings, even under the old will. So how is he kicking my brother off the property that was the only one paying the taxes? So now no taxes are being paid, because my oldest brother's trying to get the state to come on board, because when you're not paying the town taxes, now they're going to try to expedite everything. Kevin was paying the taxes right up to date since my mother's been dead, because he lived there. He has a house built on this land. That this is absurd, and I can't believe that this court is even stalling for any moment where we can just put this to bed and we can all move on with our lives.
Okay.
Okay, even if there's any merit to anything that he's saying, like, after so long, you just tune it out. I don't even know what he said. I don't have a clue. I heard a few buzzwords in there, but dang, man. Breathe.
All right. Like I said, I'll take another look at it and I'll issue a ruling. Okay.
I thank you.
Thank you very much, Your Honor.
All right.
Thank you very
Have
much.
a good rest of your day.
Stephen,
Thank you.
Thank you, Stephen.
We'll
Yep.
stand in
Stephen,
adjournment. Thank
you're
you.
up. Yep, thank you
Thank
very
you,
much, Your Honor. Bye-bye. See you, Stephen. Hey.
And I think I figured out why his brother had disconnected from the meeting. I just a little guess. He did not sound sober. Oh, so that was number one. And now let's move on. I agree, Earl. That's such a sweet greeting to everybody, baby boy. Yes, please. Please and thank you. With a giant Black's Law dictionary on top.
Ms. Bridgeforth, can you please
Hello.
unmute, and can you turn your camera on, please?
Yes. Can you see me?
No.
Can you see me now?
Yes.
Okay. Hi.
Oh. Okay. You are sideways, though. I don't know if you can. There you go. Thanks. Okay, just a moment. We are here in the case of Darnell Gay versus Cheyenne Campbell, case number 25-055154PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Miss Gay's appeal of Judge Denenfeld's order denying a personal protective order. Judge Denenfeld's denial being dated June 9th of 2025. I do see that we have both parties here, and at this time I would ask both parties to state and spell your full name for the record. We can begin with Miss Gay. You'll have to unmute, ma'am.
The name is Darnell Gay. That's Darnell, Gay, Gay.
Thank you, ma'am. And do we also have Miss Campbell?
My last name is Bridgeforth, and my first name is Cheyenne. CHEYENNE BRIDGEFORTH.
All right, thank you, Miss Bridgeforth. And were you formerly Miss Campbell?
No, my name was never Campbell.
It's always been Bridgeforth.
Yeah.
You're just named in this particular petition as Cheyenne Campbell.
Yeah.
All right, very well, thank you. Well, the way this is Ms. Gay's objection to Judge Denenfeld's denial. He responded to the original PPO while I was on vacation in June. And what I'm going to do is I'll take some testimony from Ms. Gay regarding the allegations in her petition. And then I will also take testimony from you, Ms. Bridgeforth, regarding why you disagree with that petition. And then I'll make a decision. And unless you agree at this point, Ms. Bridgeforth, that a protective order should issue, and in which case I guess I would just issue a protective order in favor of Ms. Gay. Is that what, do you wish to have a hearing at this time, Ms. Bridgeforth?
It doesn't matter. I received these papers, so I'm here.
Okay, all right, very good. Well, I'll go forward and I'll have Ms. Gay testify as to the basis. So, Ms. Gay, if you please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth? You're going to need to unmute again, Ms. Gay. I'm sorry.
Yes, I do swear to tell the truth and nothing but the truth.
Thank you, Ms. Gay. Ms. Gay, one of the bases for your petitions here is that Ms. Bridgeforth assaulted you with bleach, causing you to have to go to the hospital. Can you tell me when that happened and what happened?
I don't have an exact date. I apologize. It could have been around or about June the 2nd. I have to remember.
Of 2025, this year, ma'am?
That is correct.
If someone threw bleach in my face and I had to go to the hospital for it, I'm pretty sure I would know what day it had happened. It would be etched in my memory by the caustic bleach.
All right. Well, you filed this on June the 6th. About that. Oh, you can just say in June of 2025 is fine. And what did that look like? What happened?
So Cheyenne assaulted me with bleach. I was not causing any harm, any disturbance towards her at all. Since that has occurred, Your Honor, I have been to the doctor, the eye doctor, more than 3 times. That's why I have these shades on right here, because my eyes are damaged and I'm still waiting for them to heal. Miss Cheyenne also, she's threatened to shoot my home up.
Well, let me go back to the bleach assault. I want to take these one at a time. Were you in your home when that occurred, or where were you located?
I was on the next street over. So I was over on the next street where she lives, around about where she lives in the street.
Okay, around Hall Street.
Correct.
And what were you doing there? Were you on the sidewalk or vehicle?
I was in the street. I was in the street.
Okay. And what was I mean, were you crossing the street? Were you, what were you
No,
doing?
there was an incident going on that was happening over there, and I was trying to diffuse the incident. And when me trying to diffuse the incident, I got insulted with bleach.
All right. And who was the incident between that you were trying to diffuse?
So it was Cheyenne, some my nieces. That's who it initially started from, because Cheyenne and a couple of other people they keep doing this, going to my sister's house on Alexander and trying to cause a ruckus at her house. So then I guess from what I can take, because this is hearsay because I was not there, that they were supposed to be coming to my house to fight at my house for whatever reason. I don't know, because it's just me at my home. And I'm not understanding why these fights keep coming, or they keep calling the police to my home when it's just me, and threatening to shoot my house up.
All right. So your nieces are over there. They're squaring off with Miss Bridgeforth and other people.
Yeah.
And you felt like you could go over and break
Defeat.
up the fight. How did you go about that?
Well, first, before the fight even started, that's what I was doing. When I first went around there, I'm like, hey, what can we do to stop this incident from happening? So I'm looking at Cheyenne and her mom. And so I'm like, what can we do to, all of a sudden, Cheyenne says, well, they're messing with my boyfriend. And I'm like, okay, the twins, she's talking about the twins. And I'm like,
These are nieces of yours?
yes, yes,
okay.
they're.
You know, I agree. The whole I don't know why this keeps getting brought to my house. Woman, you interjected yourself into something that clearly you didn't have a place in. So, maybe it's because you're inviting the drama to you.
With her boyfriend. Then all of a sudden, as I'm trying to stand there and trying to diffuse this, a big fight outbursts. So then I can't do anything, I'm just like, oh my, and it just a bunch of stuff was happening that I really can't recall a lot of the stuff because it was just too much going on. But all I can remember at that point was her mom in the back of me. I remember that. And she's in the front of me. Bleach is coming from the front. Cheyenne in the front with a big gallon of bleach, douching it on me, and whomever, which I'm saying is her mom, because that's all I remember.
Okay, so Cheyenne, in your recollection, or you're telling of the incident, takes this bottle of bleach she's holding and she splashes it. It hits you and also some other people that are in that group.
I don't know. I'm talking about me. I don't.
Okay, it hit you, and where did it hit you?
In my face, and I felt some going in the back of me. It was all in my face.
All right. And what did you do after that occurred?
So I just was like, I'm not even causing any harm to her for her. That's what my initial thoughts is. Like, why would you threaten me with bleach? And I'm not even causing a threat to you or anyone else around here. You're just trying to be mean and nasty. But she's been doing stuff like that, like mean stuff. She's just.
And you said you went to the hospital following the bleach incident?
I did.
Okay. And did you also file a police report?
I did.
And what did the police do in response to it?
They were saying it was a mutual fight. There's nothing they're going to do.
Okay. All right. So no criminal charges ever came out of that thing?
No.
Okay. All right. Now, you said there was another incident where she threatened to shoot up your house. When did that happen?
That has happened since last year, and then more. It's been an ongoing thing. I was trying to come down there and send you pictures of her and her boyfriend with the gun. And then I was also going to send you pictures of her laughing at the fact that she poured the bleach on me.
Okay, and where did you get those pictures or images? Where'd you get them?
From my niece.
Okay, and were they on social media or something, or did
Yeah,
your niece?
yeah,
Okay,
yeah,
she posted some
yeah.
information on social media that you have like paper printouts of?
I can print them out if need be. Yes, I have that.
Okay, or you could, if we did continue this hearing at the courthouse, I suppose you could bring it into the courtroom so I could see it.
Yes.
Okay, all right. And is it also on that social media that she posts her threats to shoot up your house?
Yes. Her and her mom. Her mom, when after the incident happened, they threw eggs at my house. Her and her mom, she posted on the internet like how she's gonna shoot my house up. Her mom, every
When you
time
say she, that's Cheyenne you're talking about.
yes.
Okay.
And then her mom, every time I go open my door, she's yelling and screaming how she should have shot me this day, that day. Your Honor, I've done nothing to
This is
be.
Cheyenne's mom that you're talking about, Miss Gay?
Cheyenne's mom was the one yelling, yes. And I
Okay.
have on
Well, it's
that.
the PPO is not against her. You can always swear one out, and I can evaluate one against her, or another judge can. We randomly assign these, but this one's only against Cheyenne. And so the main incidents, it sounds like, with regard to Cheyenne, at least that we've covered so far, is the bleach, and then the threats to shoot your house that she posted on social
And
media.
throwing and vandalizing my home.
Okay, what does that look like?
Throwing eggs.
Okay, you saw Cheyenne throw eggs along with her mom?
I have a camera, but when I seen the camera, like I'm pulling it up, like I can't believe this because she's yelling. Her mom was yelling, I didn't throw no egg. I'm like, I don't even talk to these people. I don't know these people. All I know them from, because the first time I ever met Cheyenne was in a threatening manner. It was very disrespectful. She's not a friend of mine. As you can see, I'm 61 years old and she's much younger than my grandkids.
All right. And you also said she has thrown trash in your yard. What does
Yes.
that look like?
Okay, so the neighbor, her and the neighbor, right? Like, that stays on the side of me, right? They used to live to the left of me. She used to frequent visit their homes, right? So that's how it all started because Cheyenne started this incident when she pulled out her cell phone. My daughter was talking to her daughter. Cheyenne pulled out her cell phone and started recording in my yard. And then my granddaughter asked her not to record her mom and her sister. From that point on, Cheyenne's reaction was, F you and run up. And she was going in the street, run up and all this stuff. And from there on, Your Honor, this has been an ongoing battle. So from that point back to the trash she was throwing in my yard, her and two of the other girls, like the one next door and whoever the other girl, were walking past my house and they threw like they took a pregnancy test and just threw it in my yard.
And did you see Cheyenne throw it, or was it one of the other girls? Could you tell who actually threw it?
It was Cheyenne.
Okay. And was there any reason to throw a pregnancy test? Did it have like a secret meaning, or was it just what they had in their hand at the time?
They just have been mean. Okay, there's no secret meaning because this shouldn't even be going this far. I shouldn't be having to talk to you. I shouldn't have to be spending my money. I shouldn't be having to plead for my safety from these people. I've done nothing to them.
All right. How long, well, first of all, Ms. Gay, how long have you lived at your address?
I lived at my home almost 30 years.
Okay. And how long has this conflict been going on with Cheyenne?
Almost a year.
Specifically, about a year. Okay.
Not
All
even.
right. Anything else you need to tell me now to support your case before I get Cheyenne's side of the story?
Let me see. Let me make sure. So just to let you know, that gun, I do believe that her boyfriend was caught with that gun. He was arrested. So if I need to bring you these pictures, I can show you her in the picture with him and that assault rifle. Like, I'm like wondering why? Why are you picking with me?
All right,
You
well,
don't even
let me hear what Cheyenne has to say, and then I can make a determination whether or not I'm gonna need to see the evidence in the courtroom or not. And I can make a ruling on whether or not the PPO can be in place or not. So, Cheyenne, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I swear that everything that I will say will be the truth.
Very good. Cheyenne, what do you say about let's start at the beginning of things with the allegation that you threw bleach in Miss Gay's face?
Okay, so this incident happened on May 31st. That's when it happened. That's when everything happened. So basically, Miss Gay and her daughters, Keisha and Keena, they came to my house with her granddaughters and her nieces to come fight me. Mind you,
So this
I
is
never.
like 6 girls or 4 girls?
It was both of her granddaughters and then her nieces. So her nieces are twins.
Yeah, okay.
So it was 4
four
of them,
girls.
and then
Yeah.
it was 2 adults, which her
Are
daughters.
they about your age, Cheyenne? Are they older, younger?
Who?
The nieces and the granddaughters.
The nieces are 18. I think they just turned 18 in December. One of her granddaughters is 19 and one of them is 15.
Okay, so they're your age or maybe a little bit younger.
Yeah.
Okay, and what happens? What is the fight in the street? How does that materialize from your perspective?
Okay, so only reason I assaulted her with bleach was because her daughters was jumping my mom, and my mom was leaning on her car, and her, Miss Gay, and her other 2 daughters were surrounding my mom, and then one of her daughters was hitting my mom with a pole, and the other one was fighting my mom, and Miss Gay was just standing there like pushing my mom on the car while my mom was literally fighting her daughters. So I was thinking the first thing that come to my mind was like, help my mom. So I couldn't do anything, so I just grabbed the bleach and I just started pouring the bleach on all of
Was
them.
the
It wasn't
bleach
just her.
outside? I mean, how did it get out into the street in the first place?
It was on my porch. Like
Okay.
I have an outside porch, and we didn't wind up bringing in all the groceries and stuff. My mom had went shopping, and it was just left on the porch, on the table on the porch, and I just grabbed
So
it.
in your view, it was a weapon of opportunity, and you're not disputing it. Doesn't sound like that some of it could have gotten in Miss Gay's eyes in that whole fracas.
I'm not denying that it didn't. It most likely did.
Well, thank God that, mom hadn't, just gotten back from Harbor Freight or, Ace Hardware or something like that with a whole bunch of power tools that she could have used as weapons of opportunity. What the heck? I mean, seriously.
You agree no charges, criminal charges ever came out of that big fight?
No.
Okay. All right. So she did get some bleach in her eyes. Your story about how, you're describing something that would sound in criminal world like self-defense. This is, of course, these are civil cases, so my burden of proof is different. I just have to determine if there's enough evidence to think that something occurred. So it doesn't sound like you dispute that it occurred, but you're disputing what led up to it.
I have evidence of her granddaughters texting me, telling me to come to her house, and I have the videos of Miss Gay driving her car in front of my house. She brought her granddaughters and her nieces to my house to fight. I never once talked to them that day or anything. I wasn't even aware of them coming to my house. I wasn't even home at the time. I was home, but I wasn't on my porch. I was across the street. So when everything happened, it just was like,
Yeah, and I guess what you're saying is your view of that set of incidences was it was created by for better lack of a better term, Miss Gay's family, kind of initiating the confrontation via some social media messages.
Yeah, I did.
All right. Well, I'm on the topic.
But I never once said anything about shooting her house up or anything, or I never threw eggs
Even
at her house.
after that confrontation in the street, you never made any threats to shoot her house up or have your boyfriend do it if he's the guy with the gun?
No, I never did.
Okay, so you're denying that those things occurred or exist.
But I do admit to assaulting her with bleach. I did that. I never threw eggs at her. I never said I was going to shoot her house up. I never said any of those things.
Okay, man, it sounds like there's bad blood between your mom and Miss Gay, and that maybe those two have had
No, it's
words.
bad blood between my mom and Miss Gay's daughter.
Okay, all right, and maybe that has resulted in. Can you give me a picture of how close your house is to Miss Gay's house?
I can show you.
Okay,
Like her house is literally right here. I live behind her.
got that. You're looking at the back of her house is out
Yeah.
the back of
Out-
your house.
Yeah.
Okay, all right. No, that's helpful. So your, I guess, backyard neighbors is what I would describe that as. How about her argument that at one time you threw a pregnancy test into her yard when you were walking by with friends because you were angry? I don't know if it was at her daughter, where the confrontation was. Did something like that ever happen?
I didn't throw a pregnancy test there, but yes, my friend did.
Okay, why'd she do that? If you know.
She just didn't like Miss Wanda. She just felt some type of way. I never knew her. Like I never got to know her. I just was at my friend's house. This happened in September. This was last year, September. So like it
Before
was
this, yeah, then it was
before this, yeah,
before the
this
big incident in the street.
Yeah.
Okay.
That's so gross. Why? Why? What? Classless trash hoe. There's nothing else but classless trash hoe.
Something kind of was building up along the way there. Okay, all right. And do you ever have occasion to go to her house for any reason?
No, I lived here for 3 years. Like I never once had an issue with her or anything. So it's just crazy to me. Like I've seen her all the time. I even seen her walking down the street, knocking door to door to ask people to register to vote with her grandson. So I never really wanted to assault her or wanted to make an issue with her. It never was that. It just was they were jumping my mom, and she encouraged it. She encouraged to bring her granddaughters to my house and her nieces to my house to fight me.
All right. Well, sounds like that was really whoever started whatever happened out there was what I'd refer to as a pretty out of control situation. At least by the time things ended and the bleach got poured, you were feeling like your mom was in danger, and of course, Miss Gay was probably feeling like that bleach might screw up her vision, like bleach will do. So I get it. That situation got way out of hand. All right.
Your
Well,
Honor,
anything else you need to? I'm going to give you a chance, Ms. Gay, to respond, but let me ask Ms. Bridgeforth, anything else I should hear from your side of the story?
None really. I just feel like I did what I was supposed to do. I was defending myself and my mom and everyone that was at my home, because it was my daughter was at my home too. So it was not like I just wanted to bleach her on purpose. No, she encouraged what she did. It was never like intentionally, but it
If
happened.
this is a criminal case, we would say you did it, you thought you were acting in self-defense at the time or defense of another person, is the way you told it anyways. How old's your daughter, Miss Bridgeforth?
She just turned 2.
Okay, so she's pretty little.
Yeah.
And do you own a firearm?
No, I don't.
Okay. All right. Ms. Gay, what's your response?
Your Honor,
what
her
she said?
stating that I brought them, she know I wasn't there. My grandkids went around there. I heard the argument occurring. I never brought anyone, and she knows that. There is proof of her and that bleach throwing. I never put my hands on her mother. I never touched anyone except her boyfriend that was beating my daughter in the head with his gun. So how could you say something like that? I am 61 years old. Never in my life have I ever had any kind of record, or as long as I've lived in this neighborhood, all I've known, as she stated, you've seen me going around and petitioning for people to vote. That's exactly what I do. Never would I have encouraged my grandkids. I was going to get my grandkids. How could I go get someone, as I stated to you, if I brought them? They were not in the car with me. And she's telling
Yeah, well, I don't really have to make a determination on the exact. These hearings aren't really designed to do that. And fortunately, the burden of proof, if it was a criminal case, of course, you'd have to prove assault beyond a reasonable doubt, and she'd be entitled to a defense of self-defense, and we'd have the proofs, and then, a jury would ultimately decide that. These cases on protective orders are designed to be quite a bit different because the burden of proof is much lower. That is, I can grant, and it doesn't create a criminal record. Even if I rule and give you a protective order, all it does is order Miss Bridgeforth to not have contact with you, from the date the order's in effect. So, and it doesn't create a criminal record or a negative mark on Mitch Bridgeforth's record. And once it's gone, they actually do disappear. They're removed from the law enforcement information network. It's as if they never occurred. So it's kind of they're called peace bonds, that they used to be called peace bonds anyways. And their main, design is to keep the peace when neighbors or other people in the community have a dispute with each other. So, and I have heard the testimony today, and what I'm going to find today is there is a preponderance of the evidence that the bleach incident did occur. It's unclear, as to what happened before that, but it's very clear, that the bleach would be a dangerous substance. Anyone that's ever looked at a bleach bottle knows it says don't come in contact with your skin, and heaven's sakes, not with your eyes. So that would be from Miss Gay's perspective, a threatening incident, towards her, even though, right, it may have been in the context as it was described this time as a much bigger fight with a lot of, a boyfriend and another mom and other people involved. It sounds like, this was quite a confrontation out there in the street. And then the second incident, there have to be two incidents to support the PPO, and the second incident, I will note that Shan does deny either yelling across the yards or whatever. She says, well, that wasn't her, that was another person, and also the shooting up of the house. Either her or her boyfriend on social media. However, she does acknowledge that she and a group of friends went by and the friend tossed some trash in. Now, I do know enough that when three friends are walking along and they're talking, if one of my friends tossed something into a neighbor's yard, well, I'd probably get down, pick it up and say, I don't want to tick off my neighbor, or, I want to keep the peace in the neighborhood. And that didn't happen there. I could see how that would be an unwelcome or what could be construed as a harassing incident. So what I am going to do is I'll reinstate the PPO. It'll be effective today. I'm not going to grant it, though, all the way as requested, because it would be impossible it sounds like to me anyways, for Miss Bridgeforth to not appear within your sight. So I'm going to cross out the language appearing within your sight, but keep the rest of it the same as it's requested. Ms. Bridgeforth testified she doesn't own a handgun herself, or a firearm, so she is prohibited during the course of the order from purchasing or possessing a firearm. And Ms. Bridgeforth, if that changes and you want to petition the court to change or modify the PPO, you can bring an order. The PPOs only last 6 months as they're in place, so I'll make it effective as of today, and I'll carry it forward for 6 months from today's date. We are at July the 16th, so by my math, I'm sorry, we're at July the 18th. My prescription is getting out of date here. So that'll take us out to, let's see here, I believe January the 18th. So I will I'll keep this in effect until January the 18th. If there are additional incidents between now and then, Ms. Gay may petition to renew the PPO and continue it. As long as you do that at least a week before the PPO expires. You can do that with the PPO office, and of course bring in any supporting evidence you have. And during that time, Ms. Bridgeforth, you should observe it. And of course, it requires that you not, like I said, follow Ms. Gay, appear at her workplace or her home, approach or confront her either in public or on her property, enter her property, send any electronic communications or regular mail to her, contact her by telephone, and that of course includes texts or other ways of communicating. and you can't place any objects on her property. You can't threaten to kill or physically injure her, and it sounds like per your testimony today, you haven't done that in the past, and that's not going to be a problem. And you can't threaten to do any of those things on electronic media, nor can you even, insult her or say, I don't like this lady, or I got a beef with her in my neighborhood, because it could be construed that you wanted other people to tell her and pass that on to her. So I know, for a lot of people today, social media is a way to communicate. Just keep her out of your social media accounts, because the order is going to cover that as well. It will be effective today. But as I said, I've heard from the parties, and, I always say when I have the two parties appear for the hearing and they can both speak clearly about what happened, even though they don't agree with each other, that usually bodes pretty well, because that means people are willing to respond to court orders. The worst time is when I have someone that won't respond to one of these and I have them arrested, and then they're ticked off at me and everything else. It's like the whole system's against them. And, what I'm encouraged by here is I've got two women, very different ages, but both who are willing to do this the right way and work through the system and work out the difference just by staying away from each other. And I said, it's I guess I liken it to the, it's a brief timeout from contact with each other while the order's in place, just to let things cool down. I think, from what I heard about the fight in the street, I think it's going to benefit everyone if you guys just keep your distance. And my hope is that in 6 months, you'll say, well, things have been going okay and we don't need this anymore. But if that's not the case, you can always ask to renew it. So I guess what I'm trying to say in a long-winded way is I appreciate you both being here and your testimony today. Thank you both, and I will sign that order and get it out the door.
Thank
Anything to be brought up by the parties at this time, state or defense? We're in recess till 1:30 on this case. David, let's get your stuff done. Thank you. I need Brittany Armstrong. Come on up.
That's the Lois is here.
Yeah, I see. Hey, get us outside right now. Tommy, come on, we need some help here. Okay, we have three individuals here. As the court would place in the record, within the last hour, the court received a verdict from the jury in the case of Steven Angel in a murder case, and the jury found the defendant guilty of the offense of murder as alleged in the indictment. So the court accepted the verdict and then broke for the lunch hour. And as participants and the jury and spectators were leaving the courtroom, this court saw some activity at the doorway, and I could see one or two bodies, and it was obvious that physical confrontation was going on at the doorway, inside the doorway, and at the doorway of this courtroom, as the court was still in session on this matter. I've reviewed a video because we got videos everywhere. And I see three people flailing, punching at each other at the doorway of this courtroom and breaking some of the chairs outside. But it was a free-for-all fist fight going on. Y'all three, I recognize all three of you. This is a court of justice, a courthouse of justice, of honor. This is the last thing that should ever happen in this building because we're trying to resolve problems in a humane and dignified and educated and advanced method. We're not cavemen, although you three acted like it, like we were back in the caves again, without any rules, without any sense of respect for each other. The proceedings moved forward in due process. The jury had their job, the attorneys had their job, and then we went through the penal code, the code of criminal procedure, and the rules of evidence to get to a disposition in this case, like we do in every case, using the rule of law, not fist fighting in front of the public. Can you imagine if this is what we did normally? We don't really need a building. We just meet and punch it out. We're not cavemen. We're supposed to be advanced thinkers. But not everybody thinks advanced thought. That's foolish. That was foolish. And I see assaults. Now, I understand that no one wants to press charges against anybody. But let me tell you this, I'm pressing the charges. You do it at the door of my courtroom while in session, you're going to get held in contempt of court. All three of you are charged with contempt of court. Carries with it up to 60 days in jail, 180 days in jail, 6 months, 6 months. And don't think I won't set an example, because this isn't going to be the kind of activity that decent, law-abiding, advanced human thought in America is supposed to be about. And it'll be made an example out of. And we got the video, and it didn't happen exactly in my presence. So it's going to be what's called constructive contempt. It still happened over this court's authority and power at the door of its courtroom while in session, which means I can't hold a hearing right now. But what I'm going to do is you're all arrested. You're going to go to jail, and we'll bring you back, and we'll have hearings on each of these cases, and I'll get to make the determination up to 6 months in the county jail. And don't you think I won't make an example, because this isn't the kind of behavior which you can do and then walk away from it as though nothing happened. We're supposed to set examples of behavior for all of us. And some of these cases have terrible situations. I presided over the James Byrd murder cases. I was one of the prosecutors. You don't think that was hostile? Because there were a lot of folks who felt like justice needed to be served in different ways. But we did the rule of law. The rule of law worked. Those people were prosecuted and then executed for what they did. You don't think that the experience and the sacrifices that we put in to see humanitarian ways of doing justice and the rule of law and due process works? Or is there another way? No, it worked so that the people knew that this Constitution, the flag, and the rules in the Constitution are something to be honored, that we handle our problems in a disciplined, mature, advanced method so that we are the example for the rest of the world. But that's not the way that worked out there in that doorway. All y'all did was acted like the kids do at school grounds before we learned and get educated, duking it out there in front of everybody. People are here to resolve their problems in an honorable, disciplined way under the rule of law. What kind of example is that set that y'all can duke it out and just flail at each other, break things, and disrupt the proceeding? Disrupted my proceeding. I had to stop the proceedings that we were conducting here to finish this. But you got my attention, and you're gonna have hearings, each of you, and I'll get to make the decision because you don't have a jury trial. It's in front of me. And you can be ultimately sentenced in jail up to 6 months. Does everybody understand that? All of you? Okay, I need everybody's names. Yours first, sir.
Charles Nicholas Jr.
All right. Spell your first name. Is it Charles?
Yes, sir.
Your middle name, sir?
David. David
And surname, last name?
Nicholas. Nicholas.
And you, sir?
Charles Nicholas Sr.
And you, sir? Your name?
Last name Angel. First name STERON.
How do you pronounce that? How do you pronounce it? Steron? Steron?
That'll do.
Okay, what we call this is what's called constructive contempt. That means it didn't completely happen in the court's view, but it happened where it disrupted the court's lawful duties
That'll do, donkey. That'll do.
in our hearings because it all occurred at this doorway. Turn your phone off, please. Thank you. It's called constructive or indirect contempt. And again, this is what's called criminal contempt rather than civil contempt because you can be placed up to 6 months in the county jail. So all of you will be arrested. Each of you are going to be, there's a bond that I'm ordering of $1,000 in each case. For each case, I'm going to set this for a hearing in 4 to 6 weeks. And if you're unable to hire an attorney, one will be appointed to represent you. Are all of you going to be able to hire attorneys, or are you going to need appointed attorneys? Sir, you're going to hire somebody, and you, sir, Ms. Point, you want somebody? We're going to get you to fill something out. I need him to do an indigent form. If you're indigent or unable to hire somebody, one will be appointed immediately to help you. Okay.
You need the help. Get the help.
Y'all hold on, we're gonna take him into custody properly before he fills that out. We'll take those cuffs off.
That would be done later. Okay. I think that's, you've been given notice of what you're charged with. Assault is under section 22. A person commits an offense of assault if the person intentionally, knowingly or recklessly causes bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. The offense is generally for assault, a Class A misdemeanor, which carries with it up to 1 year in the county jail. But the court on proceeding with contempt in a contempt proceeding, again, can sentence the offenders up to 6 months, but you have an opportunity to be heard with due process and present evidence on your behalf in to answer the proceedings. And again, criminal contempt is punishable because It concerns an act which affronts the dignity and authority of the court. And the primary purpose of criminal contempt proceeding is to vindicate the public authority. And committing assaults in the doorway of a courtroom where in this courthouse where justice is the determining goal in all of our proceedings in a dignified and non-hostile way of advanced human actions and thought. That's the way we're supposed to conduct ourselves. And every case has emotional issues. We never have problems like we had just a moment ago. And that cannot be tolerated, and it will not be. It will have its punishment attached to the actions. Does everybody understand? All right, that is all. We're in recess on this. Then you are all taken into custody and $1,000 bond is ordered.
No, we'll take care of it. We're gonna have a story all
Sure, yeah, talk to the bailiff and they'll work it out with you. Thank you. We're in recess.
State of Ohio versus Katarzyna Wilson. Good morning. Ms. Wilson, you're before the court today under case 25 TRD 06419. That's for a traffic ticket you received on July 7th. You are accused of operating a vehicle while your license is under suspension. This offense carries up to $1,000 fine and up to 500 hours community service work. It does not carry any jail time. Did you watch the video?
Yes.
Do you have any questions about your rights? And how do you plead to the charge?
No contest. If I could explain the situation a little bit, it might.
In just a moment, I'll give you an opportunity to do that. Okay, suspensions. And ma'am, I will enter your plea of no contest. I've had an opportunity to review the citation and review the official record of the Bureau of Motor Vehicles and find that your operation at the time of this offense did violate the law of driving on a suspended license. Now, you have something you want to explain to me?
Yes, so originally I was pulled over, I think it was in May, for speeding.
Mm-hmm.
And it was a sheriff, I believe. It created kind of an uncomfortable situation because he kept going back and forth as to what the speed limit actually was on that road. First he said it was 25, then he said it was 35, and the situation was just kind of, you know, I asked him where the signs are. He said there was new signs on the road and everything else, and I didn't want to, you know, cause a disruption or whatever, so I just said, you know, I just accepted the ticket, and so he didn't really say much of anything else, and he didn't really explain the situation, and so I was not able to attend court for that speeding ticket. In the morning of, kind of in a hurry, because of other personal things going on, I just went ahead and paid the fine. It wasn't a big...
And according to this, you did not prove insurance.
Right, he didn't ask anything about it, he didn't say anything, and so I didn't realize that was even an issue.
All right.
And so then when I actually got pulled over one other time that was just, I don't know, just like some sort of a check or something, which would have been in between those two. Nobody ever said anything about the license. The officer just kind of checked in with whatever, the main office, and he just let me go. I'm not even sure what it was about. And so then when I got pulled over this time, I wasn't aware that it was suspended.
Okay.
I wouldn't.
I understand the situation. Let me back you up for a second because I think I'm figuring this out.
Okay.
You paid this ticket. It didn't have proof of insurance. You were sent a letter by the Bureau of Motor Vehicles on May 13th of 2025 to submit proof of insurance. They did not receive it. They also sent you notice of the suspension on July 5th to an address 2267.
It should have been 2262.
All right. So, ma'am, they send notices to the address that you have on file on your driver's license.
Okay.
That is why Ohio law requires you to be responsible for keeping your address current with the B&V. So they sent this out notifying you you were under suspension, but it appears you did not get it because the address isn't right. Okay. But it is the address, I see paperwork that they sent it to the address that you have on file.
Right. Well, I did tell the,
Yeah, and that's where you started having problems. You've got to keep your address current with the B&V under Ohio law so that you don't get into this situation. Okay? So instead of the $1,000, you're fined $150 plus the costs and fees. And if you'll just step out with the bailiff, they'll help you process your paperwork. And next we have Amber Desbennett. Are you Amber Desbennett?
Yes, ma'am.
All right, so Ms., you're before the court on a warrant issued for your arrest when you failed to appear before Judge Stansberry on a contempt hearing. This matter will be referred back to Judge Stansberry, who's already set your bond at $5,000. And so, ma'am, if you post the bond, you'll be released from jail until the new hearing before Judge Stansberry. If you don't post the bond, you'll stay in jail until that new hearing. Do you have any questions?
Could I do the order so I could get home to take care of my daughter?
Did you name your daughter Meth? Because that's the only thing you've been taking care of. You can tell by the sores on her face and the bags under her eyes. Yeah, she's in it bad.
Your bond was already set by Judge Stansberry when you didn't show up. Yeah. So you'll have to post the $5,000 or have a bail bonding company post it for you before you can be released.
Yeah, I'm sure I'll get on that.
Ashley Holland Matthews. Are you Ashley Holland Matthews? Ma'am, you're before the court under case 25, CRB 00867. You are charged with an offense of domestic violence. It's alleged on July 14th that you did knowingly cause or attempt to cause physical harm to a household member, to wit, Christopher Weekly. And, ma'am, do you understand what you're being charged with?
I do. I just don't agree with it.
Well, that's fine. I didn't expect you to agree with it. I just want you to understand what's going on here. Okay, and so did you watch the video explaining your rights?
I did.
And do you have any questions about the video or your rights?
No. I don't. No, no.
All right. And then how do you wish to plead to the charge?
Not guilty.
I couldn't hear you.
Not guilty.
All right. Would you like an attorney for your case?
I would.
Ma'am, you're going to have to speak louder. I can't hear you.
I would like an attorney.
You would like? Do you want a court-appointed lawyer?
Yes, please.
Did you fill out that paperwork?
I will. I didn't get presented it yet.
Okay. As soon as you get that, be sure you fill it out. And we'll process your application for a court-appointed attorney. Now, ma'am, the state of Ohio has made a formal bond request in your case. And they have requested, due to your previous criminal record, that your bond be set at $5,000 and that you be ordered not to consume alcohol or drugs and to have no contact with Christopher Weekly until the case is concluded.
Ma'am, I haven't done anything in almost 5 years. That charge before was my first ever charge ever in life, and this is my second. I work, I do everything I'm supposed to do. This isn't even right at all. I shouldn't be standing here at
That's
all.
all the more reason you need to speak to an attorney as quickly as possible. So get that paperwork filled out.
Nope. I don't know that I have even close to the money that I'm gonna need to get out. My son's supposed to start football conditioning tonight. Like, I have a lot that I'm responsible for.
I understand, ma'am. This is a very serious charge. The state doesn't often ask for this. So they consider it very serious. And so your bond is set at $5,000 cash or surety, which means you can have a bail bonding company post your bond for you.
So there's no 10%?
No, ma'am. And you are ordered to have absolutely no contact with Christopher Weekly if you are released on bond or from the jail. You're not to have any contact by phone, text, telephone, mail, email, or social media. Any contact with this individual in violation of the court order could result in your bond being revoked, and that means you would be held in the jail until your case is over. Do you understand your bond condition?
Do bonds work with that, or do they have to have that whole $5,000?
Ma'am, they're business people. You can talk to them about whatever business arrangements they want to make with you.
I just think it's being done wrong to me.
All right,
This is
ma'am, that's why we want you to talk to a lawyer, okay? And so get the paperwork filled out and we'll process it as quickly as we can. That's all for today. Next is David Miller. Are you David Miller?
Yes, ma'am.
Mr. Miller, you have case 25 CRB 00866. You're charged on 2 complaints that allege an incident on July 14th. You're charged with domestic violence and it says that you knowingly caused or attempt to cause physical harm to a family or household member. If convicted of this charge, it carries up to 6 months in jail and a fine of up to $1,000. You're also charged with 1 offense of assault. That offense carries an additional 6 months in jail and fine of up to $1,000. Did you listen to the video or watch the video about your rights?
Yes.
And do you have any questions about the video or your rights?
No.
Do you want to speak with an attorney?
Yes.
And will you be hiring an attorney or requesting a court appointment?
Request a court attorney. I'm disabled.
Did you felt?
And also with this case also, I did not even draw any blood or anything else. I was actually protecting myself, and I got punched 3 times in the face, busting my lip, blood everywhere, and everything else.
Okay, well, that's something that you definitely need to talk to your lawyer about.
And I would love to request an OR and be able to get out and get all this stuff done.
Well, sir, the state of Ohio has filed a formal bond request in this case. That they're requesting that you not get out on a recall.
Really?
Yeah. Due to your previous criminal history and the seriousness of this offense.
I've never had no domestic violence charges or any assault charges in my life. Only for like DUSs and that's it. And like what's the other one called? Petty theft. So this is actually my first domestic violence charge.
And sir, I will enter your pleas of not guilty. Your bond is set, and the state's request is granted at $2,500, which you can post in cash or have a bail bonding company post for you. If you are released, you're to have no contact in person with Billy Hellmandaler. You are also prohibited from having any contact by mail, telephone, text, email, or social media. Any contact with that individual could result in your bond being revoked and you being held in the jail until your case is over. Do you understand the bond condition?
Yeah, I'm going after Victor, yeah.
All right. And then be sure you get that paperwork filled out so we can get you a lawyer as fast as possible and you can talk to your lawyer.
I'm talking to Lauren and everything, but I'm gonna have to be in here for a week and a half and everything, so what's we doing? What's the next court date? Is it about a week and a half and everything, or?
No, they will schedule it as quickly as we can get your paperwork. So if you go back there and fill out that paperwork and get it over here, we can get it scheduled.
Have a PD. Okay. They told me I was getting released today, but.
Nope, not going to work that way. Next is
I
Richardson.
I know.
Kenneth Richardson.
And Your Honor, it was brought to my attention as we were getting started, Mr. Richardson is deaf. He does have the ability to read lips, or I can try to help out if we want to proceed.
So is Mr. Richardson deaf?
Yes.
All right. Do you have anyone at the jail that does American Sign Language?
I do not believe so.
Okay. And what ordinarily does the jail like to do in these circumstances? This video won't allow him to read my lips because you can't see them.
I know when we've had it before, there's been times I've assisted. I have like a dry erase marker. I can write stuff out for them, or I know there's also been times that they've been brought over for their arraignment, so they can be there in person. But since we didn't find out till last minute, that's why we didn't make those arrangements ahead of time.
Okay.
He was just transported from another county on this.
I see. So here's what then I'm going to do. I'm going to continue this until tomorrow and have him brought over.
Okay.
Or can he needs a sign language. I can't see my lips. So I either have to have him here in person so he can read my lips, or we have to have a sign language.
Never ran into that.
Yeah, so who has arraignments tomorrow?
And in the morning, in the afternoon it'd be me, and it'd be Judge Landefeld.
Landefeld, okay. So then we can make arrangements, Deputy, to have him transported for tomorrow. Judge Landefeld will be here tomorrow.
Okay.
And then we'll be able to handle his case because he will then be able to read my lips, or Judge Landefeld's, I hope.
Okay.
And then next we have Kenneth Roseberry.
How you doing, man?
Good afternoon. Mr. Roseberry, you're before the court on a warrant issued for your arrest by Judge George when you failed to appear for a court proceeding scheduled in front of him. He has scheduled your bond at $5,000 cash or surety, which means that the bonding company can post it for you. And your case will be reinstated and put back on his docket.
What if I was incarcerated?
The sign language guy?
Yeah.
Here's this one.
Oh, okay, thank you.
I was incarcerated during the time that I was supposed to be in court.
Yeah. And then, so then this gets set up for a new court appearance before the judge that you were assigned to appear before.
Oh, there's no OR.
No, Judge George said no OR.
OR.
Yes, he very specifically said, no OR, 5,000 cash or surety.
Right.
Okay? So then, were you represented by an attorney in this case before you had that warrant?
I'm sure I have Brady keys.
Huh? I couldn't hear you.
Pretty sure I had Brady keys.
You think you had Brandon Keys in this
Yeah.
case?
Yes, yes, ma'am.
All right. I don't see Brandon's name. Do you have another case?
No, ma'am.
All right. This case doesn't have any lawyer on it.
All right, can I get a form for a public defender, please?
Yes, they should have them there. You can complete that form and request appointed counsel to represent you at your change of plea.
All right, thank you.
State of Ohio versus Chevy Steigerwald. Mr. Steigerwald, you are before the court under case 2025 CRB 00865. You're charged with one offense of criminal damaging, which carries up to 90 days in jail and a fine of up to $750. Did you watch the video explaining your rights?
Yeah.
Do you have any questions about it?
No.
Want a lawyer?
Yeah.
Court appointed, or are you going to hire one?
Court appointed.
Did you fill out the paperwork yet?
No.
You'll need to do that. Then, sir, fill out your paperwork and I'll enter your not guilty plea. Your bond is set at $15,000 cash or surety.
15?
Yep,
It was 2,500.
yep, it's not now. It was $2,500 if you posted it before you saw somebody to review the case.
Okay.
So you can post it in cash or by a bail bonding company.
Is it 10%?
No, cash or surety. State of Ohio versus Madison Starkey.
Grab your stuff and come with me.
Ms. Starkey, good afternoon. You have case 25 CRB 00017. You're before the court on a warrant which was issued for your arrest by Judge Stansberry for your failure to appear for your jury trial. Judge Stansberry has ordered that you be arrested and that you be held on a $5,000 cash or surety bond. And your case will then be reinstated for a trial before Judge Stansberry and rescheduled. Did you have a lawyer?
Yeah.
Who
And he
was-
said that we were going to get this warrant cleared up because it was a mix-up.
What kind of mix-up?
I'm going into the diversion program for a different case.
Okay.
And so we were supposed to reschedule my court date from July 3rd. And I still haven't got that court date, but I was supposed to come here down to the diversion office. And I've been emailing him, but he's not here. I'm not sure why he's not here.
Yeah, he's off. Yeah, he's off this week.
But he was just emailing me saying it was a mix-up.
The judge?
No, my attorney.
Oh, okay. No, I meant the judge is off. He's not here. Okay. So your attorney said that this is a mix-up and that he's going to take care of it?
Yeah. He said that I wouldn't have to serve jail time. Just come here today at 12:30 and we'll get it cleared up.
Okay. There's nothing that tells me that anywhere.
Can I show you an email?
Yes, I'd love to see it.
This is where it started, and that's him saying.
This here?
Yes, that's that. And then this is me asking to be at court. He said no.
You can just, you just scroll up.
Yeah, I
and read
can
all
just
of
look
it.
at it. Thank you.
You're welcome.
Okay, so Mr. Brigden said, I can't do it today because I'm in court. I can do it tomorrow, which is today, that he's supposed to be here.
Yes.
Right. You have to be at the court at 12:30. Okay. And then he says, nonetheless, we, meaning he, has to clear the warrant. Did he meet you here?
No, I then asked, I said, will I have to serve jail time? And he said, no.
No, of course, ma'am. That's not what you're here about. That you're here about why you weren't.
Right. He
And-
said it was a mix-up.
All right. We're going to contact your lawyer. So why don't you just have a seat there. And ma'am, here, let's give you your phone back so it doesn't get lost. We're going to call Mr. Brigden and find out why he's not here.
Your Honor,
Yeah.
I have Mr. Brigden right here. Because
Oh, wonderful. Hey, Chris was there.
Mackenzie had to take off.
Oh, she has a warrant. And I just told her that
You're done? Yeah. Just come on over here.
Mr. Brigden, and I just told her what Judge Stansberry said here and asked to call you to find out, because she said you were supposed to be here, and she showed me an email that you were supposed to meet her at noon, and that this is all a mistake.
Okay. Right away.
And then she walked out.
It's kind of a mix up on her thing. We went to court, so that then they issued a warrant on the trial date. That was a little confusing, so we needed to clear the warrant first.
Yeah, well, and the whole point is, I don't have any paperwork to that effect. All I have is Judge Stansberry issuing a warrant, setting a bond at $5,000 cash or shoot. So, did you talk with Judge Stansberry about this?
No,
Oh, okay.
no, I was just gonna have her,
She seemed like, my lawyer's supposed to be here. My lawyer's supposed
well, I
to.
was just
Oh, okay.
over there.
And maybe. Okay. Oh, okay. I thought you said she walked out.
No,
Okay.
I said that,
Okay, I misunderstood you, Mark.
that's okay.
I will go to the next, okay. So I tell you what, Chris, are you over here for pretrials?
Yeah, but I could.
Can I take this file and we'll just move over there, because I gotta do all that work.
Oh,
That's
you're-
sitting- I'm
you're
covering
doing
for
pretrial?
everybody.
Let me
Okay.
get off the record, Your Honor.
Okay,
We're on the
and
record.
that's fine. I'd like the record to reflect I'm covering for everybody.
Right.
Yeah, she was a pro tem sit-in judge. I don't know her name, but she was fantastic. And we don't get any more of that particular hearing, unfortunately. If in the process of editing the remaining 16 hours of these docket cases that I have for Licking County, if I come across it, I'll definitely share it on the Replay Crew Mini or with you guys or whatever. But yeah. Oh my goodness, what a mess up. I don't know. Normally when a defendant says, you know, oh, my lawyer said he'd be here and that it's all a mix up, I tend to not believe them, but I kind of believed her. I don't know. She came with emails. She came with proof that she tried. So
Next matter here is State of Ohio versus Patricia Daniels. It's 25 TRD 6504. You're Ms. Daniels?
Yes.
Ms. Daniels, you've been charged with stopping, I guess, failure to stop after an accident upon a property other than a street. And that's in violation of section 335.13 of the codified ordinances of the city of Heath. Is that, I don't know that off the top of my head. Pardon? Do you know what offense that would be? Pardon? You're no help. Anyway, do we have the codified ordinances? Do you have the codified ordinances of the city of Heath?
No. Oh, it's right there. I found you.
I know the Ohio Revised Code. I'm not so familiar with the
City.
codified ordinances of the city of Heath. So you get to learn. I get to learn something new today.
Right.
5:13. Okay. This be nice if they told us this, but this is a misdemeanor of the first degree. Carries with it a penalty of up to 180 days in Licking County Jail and a fine of up to $1,000. In addition, you've been charged with failure to control under section 331.34A of the codified ordinances of the city of Heath. And that is a minor misdemeanor. That one I do know, by the way. And that carries with it a penalty of up to $150 in the court costs. Do you understand those two charges against you, ma'am, and potential penalties? And you can enter one of three pleas here today. You can enter a plea of not guilty, you can enter a plea of guilty, or a plea of no contest. Do you understand what those three pleas represent, ma'am?
Yes, I do.
And do you know what plea you'd like to enter here today?
No contest.
Sure you want to do that? And I don't tell people what to do unless they've entered a plea of guilty.
Yes, but I have an explanation.
Well, the reason I'm asking that is because, as I said, the first offense is a misdemeanor of the first degree, and that's a pretty serious offense. And you may want to have an attorney advise you on that. But you can enter a plea of you can waive your right to have an attorney and enter a plea of no contest if that's what you wish to do to these two charges. If that's what you wish to do, and is that what you wish to do here?
Yes, it is.
Very well. The court will accept your plea of no contest in each of these charges as being knowingly, voluntarily, and intelligently entered. Now, it appears you were driving. This would have occurred on July the 8th of this year, and you were driving on Dogleg Road, southbound, near Hopewell Drive in the city of Heath. Apparently, you drove off to the left side of the road and struck a fence before coming to a final rest on the road. And then, according to the report, again, that's what I'm using here, you left the scene of that accident and then stopped later. Okay. It looks like you did lose control, went off the road, actually hit a fence. The court's going to find you guilty of these two charges because you did leave the scene, but you said you had an explanation here.
Yeah, I know you're not familiar with that area, but it's behind ours.
I am familiar with that area.
Oh, okay.
Yeah.
Sorry.
I drive through Heath. I'm from Lancaster, but
Okay. Well, anyway, when you go behind the street department, I lived back there for 50 years. My mom's still there, but I was going to my mom's. Once you go behind the street department, my Challenger is a stick shift. So when you leave, you go from asphalt to gravel. So when I went from the asphalt to the gravel, I downshifted to second gear, and it had rained that day. And so when my Challenger hit the rocks, they were wet, it kind of threw me in around, and I clipped one hole in the end of their fence. But we communicate with the street department. We've been there, and they were closed for the holiday. So I went on down to my mother's house, which is maybe 600 yards from the back of the fence. Took my car there. Street department was closed, so it was the holiday. And because I know the contact I have with those people, took the car to my mom's. Nobody was there, so it's kind of on the edge of city limit, but private property where I hit. So my plan was on that Tuesday to contact the street department because I know somebody has a fence company, and I planned on just fixing it. I thought because it was private property and nobody was there, I was going to contact the street department. But then the policeman, when he went on down to my mom's house, because that's where I drove the car, it's right behind the street department, it's on cameras. I drove straight down to my mom's to park the car. But then the officer did tell me, even though they were closed and it's private property where I hit, technically I still should have called the cops. But that was my mistake.
Wouldn't that have been the smart thing to do?
Well, because I don't know, I guess it's the rapport we have with the street department because we've been there 50-some years. So I assumed that the street department guys would be like, oh yeah, okay, well, street department got a hold of the police before that morning for me to get a hold of them. So it was the holiday, and they were closed that Monday, so it was Tuesday.
Do you think that the building is just, completely unattended and that no one's going to notice that their fence got damaged? A car hit the fence. Nobody's going to notice that until you get around to talking to them on Tuesday. Of course you should have called the cops, you big dum-dum.
So, I'm guilty of leaving that 100%. That's why I'm doing no contest on all this.
But you're too pretty to go to jail, right?
No. Nobody's that too pretty to go to jail.
Okay.
But
I'm too pretty to go to jail.
That's what I did leave the scene. I can't. I'm just saying.
Well, here's the thing.
It was my misunderstanding thinking about
You're going to
property.
promise me that you're going to fix that fence.
Oh, yeah, I have insurance.
And here's the reason I'm asking that, because, look, technically, we should, and some of the courts have taken Marcy's Law to a whole new level, saying that the victim has to be notified of any matters that involve either physical or property damage in order to have input. And you have a good rapport with them. I want you to make sure that is repaired. It sounds like you're trying to do the right thing. You don't have, now, here's the thing, you didn't show him proof of insurance. I hope you have that because
I have all that with me.
you've heard me say this repeatedly, and you don't want it to happen to you.
Right.
I'll tell you what, on each count here, I'm going to make it a $50 fine. There's one court cost. You'll have time to pay it. You don't have to pay it today, but you probably learned a pretty valuable lesson here today, didn't you?
Yeah, now I know.
Well, you learned it before today, so. Tell you what, just get this paid, get that fence taken care of, and you'll be good to go.
All right.
Good luck to you, ma'am.
Thank you.
I don't know where the bailiff went.
That's okay. He said wait here.
Okay. He'll guide you. All right, our next matter here is the State of Ohio versus Jaden Richmond. It's 25 TRD 6543. And you're Mr. Richmond, is that correct? Mr. Richmond, you've been charged with operating a vehicle with no driver's license under section 45.12 of the revised code. That's an unclassified misdemeanor, carries with it a penalty of up to $1,000 up to 500 hours of community service. In addition, you've been charged with failure to register having expired tags under section 4503.11 of the revised code. And that's a minor misdemeanor, carries with it a penalty of up to $150. Do you understand those two charges against you, sir, and the potential penalties?
Yes, sir. Also, like, I had, like, my expired license. Like, I don't know if that like, makes any, like, difference, but.
Well, expired's expired, and it was expired more than 6 months.
Expired more than 6 months?
That's what the allegation is.
It wasn't more than 6 months. My birthday was June 23rd. That's when I turned 21, and that's when it expired, and I got pulled over, like, for this to expire. It was last week. So it's about 3 weeks after. That's not 6 months.
Yeah.
I just turned 21.
Okay. Well, the offense could still be, I mean, it's obviously medication, right? So, do you understand those two charges against you, though, sir?
Yeah.
Penalties?
Yeah, but is it, like, is it being, like, because you said it's 6 months, like, that's what's written down? Like,
that's what's written down.
I mean, I just know that's not true, like, at all.
Okay.
Like, I could show you, like, my driver's license, and like, it's not true.
Yeah, it was expired, though, right?
Yeah.
Okay.
No, I meant that. I just, like we said, 6 months. I'm
looking at the citation. I didn't look at the report or anything, but,
I just didn't know if that made like it to like any worse or whatever. I mean, obviously that's way worse, but I just don't want you to think I've been driving 6 months without a license.
That's fine.
Yes.
Okay, so you could enter one of 3 pleas to these charges. You want to, what, do you know what plea you'd like to enter here today?
Yeah, I'm gonna plead guilty.
Okay. Court will accept your plea of guilty as being knowingly, voluntarily, and intelligently entered. Do you presently have?
Yeah, I do have I did get my registration and my license. Yeah, I just got it earlier this week. Well, actually, last week. It was on Thursday or Friday. That's when I got it.
Okay, so you've got your driver's license, you've got your registration, you showed proof of insurance. You're good.
Yeah, it was just a mistake for me. I didn't have enough money at the time to like take care of it, and I put it off for a little bit too long.
Okay, on each of these counts, it's going to be a $25 fine. There will be the court costs, and you'll have time to pay it. You don't have to pay it today, but just, make sure that you keep your registration current. Make sure that you're good for probably 8 years on your driver's license.
Yeah,
right?
I only got it for 4 years. But
Oh, you only got it for 4?
Yeah.
See, I can't get it for 8 because once you turn 65, you can only go for 4 years. Yeah, they only let you do it 4 years at a time. I found that out the hard way. So, good luck to you, sir.
Thank you.
I wonder if the judge had to go up in front of a different judge when he found out the hard way. No. Don't feel like the nosy neighbor. You deserve to know what's going on in your neighborhood. That's perfect. Perfect. Yeah, I'm so sorry. I think it's you. I'm so sorry. All I can say is maybe go out and come back in, but I don't want to lose you. Yeah, so when I think it was when Darnell Gay, the bleach case was going on, the end of that one, I got a human detection alert on my doorbell cam. And I'm like, what the heck? So I looked at the video and there was some teenager-ish kid in my yard, like between mine and my neighbor's house. And at first I'm like he looked like he was just standing up from something. so I didn't know like if he was creeping around the yards or what, but it sounded like he said, "Why me?" And then there was another kid that was on the sidewalk walking down and that said something about his house. I don't know. The audio, it doesn't always pick up the greatest, but it was, I'm like, who is this and why are they in my yard? And so I sent the video to my neighbor, the other house, which my doorbell cam covers their entire porch perfectly. Their entire porch, the front yard, everything. They are just as protected as I am, and I love it. But yeah, it was wild. Like, I think that poor kid was getting a whooping. And he ended up falling outside my front door in between the two houses because at the time my camera kicked on, he was like halfway standing up. And when the other kid was walking down the street on the sidewalk, the one that like fell in between the houses, he just continued on through my yard. But I didn't know what was going on, so I locked my doors. He was gone by the time I got out there, so because there's a little slight delay. It's not much, but it's enough that, a teenager that's walking away is going to get away before I can get up and out there myself. I love you so much. I really do. 100%. Ava's not scary. Yeah, she'll alert me. She'll alert me to everything. A leaf can't fall from a tree without her letting me know, which is fine. It's just fine. But as far as, if someone were to break in, I don't know. I think she would just howl at them. And then, I don't know. I don't know. Maybe they sense fear, and maybe if I was showing fear, maybe then she would attack. I don't know. She's just a good girl. She's not going to attack somebody that doesn't deserve it. Oh, they are. They are. Now. All right, guys. I am going to go to bed. I'm so tired. You guys kept me awake though. You did a fantastic job, every one of you. I was struggling though. That last hearing, I was struggling through it, man. But all right, let me put the end of Mr. yeah. Hold on, what am I doing? Oh my god, I'm so tired. Okay. Yeah, that was me, like half asleep right there. I dozed off right there. Right there. Oh my god. And I entered into some dreamland. I don't even know what I said. Yep. Going to bed. Yep. That was, yep. Okay. Okay. I love you all so much. Be safe, be well, sleep sweet, and much love.